Welcome back to this third segment of this law session on English legal system looking at the judiciary. Now, before the break, we're looking at how judges were appointed previously and this whole idea of secret soundings. Now, there is a point I want you to take on board, and that is this. When you look at the makeup of the judiciary, it has always been predominantly male, predominantly white, predominantly middle-aged. And so the question is this to do with the secret soundings, or is it that the secret soundings are putting people who are unmeritorious into the judiciary, or is it that it just happens to be that, yes, I have a brother judge, as it were, in chambers, and he's the one who is referring me or sounding me out for this job? Because the point is that we will see this whole transparency being set up as there are not enough women, ethnic minorities, and so on within the judiciary. But there's this drive to say, well, it should only be on merit. It should not be secret soundings. But is it that the secret soundings weren't on merit? Because what you have to be careful about, or what I would suggest was not taken on board, is that even though there was secret soundings, if it is that you set up a system where you're looking at selection on merit, will that change the makeup of the judiciary from predominantly male, predominantly white, predominantly middle-aged? Will it? That is something I needed to take on board, because it wasn't that, oh, well, then they're giving it to somebody who was not deserving. It was that the selection process, by and large, was very non-transparent. So bearing that in mind, let's look at how or what ideas or what has been advanced in respect of changes. If we look at Lord Devlin, who in his book, The Judge, said that while it would be good to open up the legal profession so that you could get the very best candidates from all walks of life, he said the nature of the job means that judges will still be the same type of people, whether they come from public schools and Oxford or Cambridge or not, namely those, he said, who do not seriously question the status quo. Now, in the second annual report, which was published in 2003, the Commission for Judicial Appointments concluded that there was a systematic bias in the way that the judiciary and the legal profession operated. Now, they said that this bias prevented women, ethnic minorities, and solicitors from applying successfully for judicial office. Now, I'm always wary of reports, because when it talks about the system, it talks about systematic bias and so on. The problem I'm having is that even if the application process was opened out, is it likely to change the makeup in terms of the numbers there? Simply because if you're saying there's not enough women, there's not enough ethnic minorities, even in the application process, let's say you have openings for 5 high court judges, and then the requirements that are there, is it that you're going to get somebody who's an ethnic minority, or indeed a woman who is going to say, well, I can meet the requirements? Will you have more people, a bigger pool of white, male, middle-aged, who can meet that criteria, as opposed to persons from other groups? That is something to consider. But in any event, the report said that there was a systematic bias. Now, the Commission was fundamentally unhappy with the appointment process for high court judges and recommended that it should be stopped immediately, because it said that it was opaque, it was outdated, and it was demonstrably based not on merit. So what I'm saying is that merit may not have been the basis, but would the persons who were secretly sounded out still have met the merit criteria if there was no such secret soundings? Well, let's look at the new appointment procedure. What we have coming on board is the government publishing a consultation paper called Constitutional Reform a new way of appointing judges. This was in 2003. Now, while some improvements had been made in recent years to the appointment procedure, the government concluded in the paper that the most fundamental feature of the system remains rooted in the past. Incremental changes to the system can only achieve limited results because the fundamental problem with the current system is that a government minister, the Lord Chancellor, has sole responsibility for appointments and the appointment process and for making recommendations regarding those who are to be appointed. It went on to say that, however well the practice has worked in the past, the system can no longer command the public confidence, and as such, it was time to reconcile what had gone on with the demands, of course, of the Human Rights Act. You can't do any discussion in respect of the judiciary without, of course, having the human rights impact. But looking at it, the point was that they considered that this needed changing. Well, there was a consultation of sorts, and we then get the CRA, the Constitutional Reform Act, coming out, and it had provisions which established a new Judicial Appointments Commission. And under Schedule 12 of the Act, the commission was to have 14 members, which consisted of 5 lay members, 5 judges, 2 legal professionals, a tribunal member, and of course a lay magistrate. Now, members were to be appointed by the Queen on the recommendation of the Lord Chancellor again. Now, when you look at the candidates, they must be selected on the basis of merit and be of good character. Now, to be appointed to the new Supreme Court, a person must either have held judicial office for 2 years or have a right of audience in the senior courts, meaning the High Court, Crown Court, Court of Appeal. When you look at the qualifications for appointment in the Court of Appeal, is either by experience as a judge in the High Court or a right of audience in the High Court for 10 years. To be appointed as a High Court judge, it is also necessary to have had a right of audience for 10 years in the High Court. For circuit judges or recorders, it can now be appointed from anyone who has had general rights of audience in the Crown Court or County Court for 10 years. And anyone who has been a district judge for at least 3 years is also eligible to be appointed as a circuit judge. Now, government lawyers, a new input here, are now allowed to become judges. These lawyers are people who are employed in, for example, the Crown Prosecution Service, the Serious Fraud Office, the Government Legal Service. They will be able to sit as civil recorders, part-time judges, as well as deputy district judges in the Magistrates Court, provided their own department is not involved in the case. Now, these provide major developments across the board, and certainly when you look at the recruitment of judges, it has provided for a change. So when you look at the new Judicial Appointments Commission and its functions, one of the things it's supposed to do is to look at the need to encourage diversity in the range of persons who are available for selection. Now, it still says that they will evaluate candidates by virtue of merit only. Now, when you look at this, again, this is why I'm saying, is it that anything has changed? Because again, is it that the persons who were being secretly sounded out were not meritorious? I would submit personally that it wasn't. It really was a situation where they may have had the merit, it's just that there was just this whole nepotism in respect of the way it was done, as opposed to saying, right, let's have a transparent process. So the idea is, if you're looking at diversity, then is the Judicial Appointment Commission, for example, the best place to set this up, to say that what we're looking at here is only to be selected on merit. And as such, if that's the case, then we will get diversity. One of the things, of course, that has come on board, and for you to bear in mind, is the Equality Act of 2010, because we do see provisions in the Equality Act which provides for some degree of positive discrimination, if you want to call it that. I wouldn't suggest, for example, that it ranks along the lines in the US, where they used to have these situations where they had what was called affirmative action, where if you had, for example, a black person, a white person going for a job, even if there was mediocrity in respect of the black person's qualifications, he could still get the job. That is not what is being encouraged in the Equality Act. The Equality Act is saying if you have two candidates of similar merit, then the law does allow you to choose a candidate based on the fact that there are these diversity issues to be addressed. And as such, there is a question as to whether or not, as you look at this selection process, whether the Equality Act will have some impact and bearing on it. Now, as you look at this whole idea of diversity, I just want to give you some statistics. When you look at 4%, when you look at judges, there are only about 4% of judges who are from minorities. 19% of judges are women. And that's overall. It gets even worse when you go higher up the rung or higher up the ladder. It's impossible to ignore the fact that there are no minority judges and only one woman so far on the Supreme Court. Now, in May of 2011, the House of Lords Constitution Committee began an inquiry into judicial appointments, and the Commission's inquiry has a remit to cover matters of diversity, accountability, and transparency of the present system, and also to clarify issues such as the relationship of the judiciary to Parliament. Now, when you look at the accountability point, we see Lord Phillips, who made an interesting interjection on this whole accountability issue and said, are we setting out to make sure that those who are appointed as judges are best fitted to carry out the duties of the judge, or are we trying to do other things at the same time to make sure judges reflect society, or that the appointment system is a democratic system? It will not necessarily lead to the same result. Pause and think about that for a minute. Because he said, which is the point I've made from I started this segment, is what is it that you're trying to achieve? If you're trying to achieve diversity, well, is the Judicial Appointments Commission the best way to go about it? If you're trying to achieve transparency, then arguably it is. But seeking transparency may not very well be the same as seeking diversity. Now, Lord Phillips' words draw attention to the key issue of judicial appointments. Does the need to diversify the judiciary come into tension with appointment entirely on merit? Because despite the operation of the Judicial Appointment Commission, the pattern of appointments since the Judicial Appointments Committee has come on board does not seem to have changed at all. And as far as the public is concerned, the process appears difficult to scrutinize. Now, Lord Phillips picks up on this point. He maintains that the system of appointments to the Supreme Court, as presently configured, allows those who are most familiar with a candidate's track record to make the necessary assessment of his or her abilities and suitability for high judicial office. Now, the reasons for an appointment are made known to the Lord Chancellor, but not to the public at large. So when you look at the appointments, as I say, even the House of Lords, even the Judicial Appointments Committee situation does not affect the House of Lords selection. That is still outside of this. Now, Lord Irving picked up on the issues relating to diversity in judiciary, and he stressed that the 2005 Constitutional Reform Act aimed to balance diversity and merit. Now, as I keep saying, you have to look at whether the two sit comfortably, and I certainly would refer you again to the Equality Act 2010 and Section 159 of that Act, because it does provide for, if you're going for diversity, then arguably it may not be the same as going for merit. I'm not saying that the two cannot coexist at some point, but arguably you have to be very careful what it is you wish for. Well, we're going to take our final break, and as soon as we return, we will look further at this whole area of judiciary. We will also touch on functions and the like, and we'll also conclude on this particular topic.